Are they getting ready to come in? All right, can y'all hear me on Zoom? You got me, Steve? All right, let's make sure my microphone's working. All right, good morning, ladies and gentlemen. It's just a little after 9. We're going to go ahead and take open announcements for the 9 a.m. docket. Just some housekeeping notes. If you are appearing via Zoom, please note that we can hear you if you're not muted. So if you are not in the hearing or testifying, please keep your microphone muted. Also, if you don't stop your video, we can see whatever it is that you're doing. And although it may be entertaining, it can be distracting. So if you wouldn't do it in a courtroom, I would ask that you please don't do it on Zoom. That includes smoking, walking around, eating, and those things. So just stop your video. And then also for those here, if you want to wear a mask, wear a mask. If you don't want to wear a mask, you don't have to wear a mask, except for the inmates, because they don't have a choice. I make them come here. And so if you want them to be in a mask when you talk to them, they're in a mask. And so with that, I'll go ahead and take open announcements on the 9 a.m. docket. Mr. Mills.
Jesse Webb on page 3 and 4. 3 and 4.
Jesse Webb. All right, these are cause number CR 20-0709, and CR 21-0110-392, both styled the state of Texas versus Jesse Webb. And let's see, that new case is set for arraignment. Mr. Mills, let's go ahead and arraign him on that one.
Yes, sir. Your Honor, his name is spelled correctly in the indictment. He understands what he's been charged with. We'll waive formal reading of the indictment, plead not guilty for arraignment.
All right, then, Mr. Webb, the court notes you plead not guilty for purposes of arraignment. Your two next court dates on this one are June the 1st and July the 6th, both at 1:30. And then on this discovery status on this 0709 case, where are we at?
I think I've received the discovery on the case. Would it be possible to just put this with those? So we?
Yeah, I'm going to hold up the discovery status on this one and let it catch up with the discovery status on June 1st on the new case. And that way, Mr. Webb, both your cases will run together. And so you're going to receive those reset notices. However, on this new case, based upon the charge, I'm going to order you to take a drug test today.
Yes, sir.
You're going to go with probation, take the test. When you get done, don't leave, come back in the courtroom. We'll go over the results together. Okay, sir?
Yes, sir.
All right.
He needs to get his reset notice. But we've excused, or
Yes,
now
sir.
excused.
Yes, sir. I see you started my YouTube, Kevin. I forgot.
Reset.
June 1st. And
We moved the microphone.
what was the second date?
July 6th,
Both at 9,
1:30.
1:30.
All right, Ms. Fulhaber.
I've got Robert Lima on page 1.
Mr. Lima, come on up. This is cause number CR 20-0552-392, the state of Texas versus Robert Lima. And this is set for pretrial. Any pretrial from the state?
No objection.
Excuse me, granted, and any on behalf of Mr. Lima?
No, Your Honor.
All right, then, Mr. Lima, the court deems pretrial is held. Your next court date is May the 5th at 9 a.m. And let's see, do we have an offer for him?
We do, Judge. The current offer is 30 years.
3-0?
Yes, sir.
Okay. All right. Well, your next court date then is status, Mr. Lima, and that'll be your last day to resolve your case by plea bargain or otherwise, or it ends up on the trial docket. Okay, sir. And we're starting trials. Got one starting this week, so we're back in action. All right, you can have a seat, sir. Who else?
Daryl Menifee on page 2.
Mr. Menifee. These are cause numbers CR 20-0694 and 0695-392, both styled the state of Texas versus Daryl Menifee, and both set for discovery status. State.
It's ready, I believe, all. Why didn't we have made an offer?
I'm sorry.
We have made an offer and all discoveries.
And what's the offer?
18 years on the assault case officer, concurrent with 5 years on the assault family violence.
And Your Honor, I do believe that there should have been a 911 call on the assault peace officer case. There's a call sheet, but I haven't received the recording.
That's why we have discovery status.
I'll look into the recording.
Okay,
And
so
there's also some medical records that I think were subpoenaed, but I haven't heard back whether y'all have received them.
And the discovery motion, that we went to, we said those are available, but we'll need to talk about some HIPAA stuff.
HIPAA stuff. All right.
Well,
Yeah, I'm having a hard time hearing y'all too.
there's some protected law enforcement
I got you.
information in them.
Okay, so if y'all can work that out, get that 911 call, I'm sure it's there if it's on the call sheet. And we'll set pretrial for May the 5th at 9 a.m. Okay, Mr. Menifee? We'll see you then. Thank you, sir. Yes, ma'am. Yes, sir.
Page 3, Ricky Hooper for discovery status.
All right, this is cause number CR 20-0530-392, the state of Texas versus Ricky Hooper, and that is set for discovery status. State.
Yes, Your Honor. All discovery has been provided to Mr. Harrington. There has been an offer, there's been some negotiation back and forth. The last offer that we gave him was 6 years with an affirmative finding,
I'm sorry.
with an affirmative finding of a deadly weapon.
Okay.
It's all correct.
Nothing outstanding.
Nothing wrong.
Okay. All right, then, Mr. Hooper, then the court deems discovery status is held. Your next court date is May the 5th at 9 a.m. and that's for pretrial. And we'll see you on that date.
Jackson, I believe, next judge also.
Jeremy Jackson. All right, it's cause number CR 20-0650-392, the state of Texas versus Jeremy Jackson. And this is set for discovery status. State.
Discovery has been provided, Judge, and there is an offer.
And what's the offer?
The offer is 5 years.
All right, and Mr. Harrington.
That's all correct, Judge. We have discovery in the offer.
Okay. All right, then, Mr. Jackson, court deems discovery status is held. Your next court date is pretrial, and that is on May the 5th at 9 a.m. So we'll see you back here in May. Snodgrass?
Yes, sir. He's on bond.
Kelly Snodgrass. Come on up, Mr. Snodgrass. This is cause number CR 20-0619-392, the state of Texas versus Kelly Snodgrass, set for discovery status. State.
State's ready. We have provided all discovery in this case, Your Honor. There are 2 offers. Both offers are going on the lesser included on a state jail. One is 2 years, probated for 3 years, or the other one is 7 months state jail.
Either probation or state jail.
Yes, Judge.
That's correct, John. I relate those offers to Mr. Snodgrass. We're making probably have a decision about the pretrial, I would imagine. Status company vetted by them. We're probably pretrial.
All right, well then, Mr. Snodgrass, then the court deems discovery status is held. And can I see the docket sheet? Sorry, I always wait till you start writing on it. All right, I'm going to order you to take a drug test today as well. You'll go with probation. Take the test. When you get done, come back in the courtroom and we'll go over the results together. Don't leave till we talk, okay? All right.
Don't leave the court. Oh. Come back.
Six, seven.
That's all.
Yes, sir. Appreciate you.
Well, I'll wait on that.
Sir, Mr. Schmidt.
8-6, Your Honor, very good.
Mary Bearden. These are cause numbers CR 20-0630 and 0631-392, both styled the state of Texas versus Mary Bearden, and both set for discovery status. State.
State's ready. We provided all discovery in this case. We have made we tendered an offer. Basically submitting an application to the defense for pretrial intervention.
Okay.
Yeah, my understanding, I haven't spoken with Ms. Bearden about this yet, but it's sort of there's an issue about if there is any restitution or not that needs to be determined. My understanding.
That was the understanding. I don't believe there is going to be any.
And we have received the discovery, Your
Okay.
Honor.
All right, well then, Ms. Bearden, the court deems discovery status is held. Your next court date is May the 5th at 9 a.m. for pretrial. So as soon as you receive your reset notice, you're free to go, ma'am.
Thank you, Your Honor.
You're welcome.
That's all I have. I'd be choosing.
Yes, sir.
Thank you,
Appreciate it.
Judge.
Ms. Thompson.
Discovery.
Martha Biat. Cause number CR 20-0666-392, the state of Texas versus Martha Biat. Biat, come on up. Set for discovery status. State.
State's ready. We have provided all discovery in this case. There are currently two offers. One is for probation, 2-year deferred. The second offer is 60 days in the county jail and 12 for
Your Honor, we have received those offers and I have gone over those with Ms. Viet. We're not prepared to make a decision on that today, and there's nothing that we need in the way of discovery at this time.
Okay. All right, then, Ms. Biat, the court notes, or the court deems discovery status is held. Your next court date is May the 5th at 9 a.m. However, I am going to order you to take a drug test today. You'll go take the test. When you get done, don't leave until we talk. Come back in the courtroom and we'll go over the results together, okay?
Your Honor, I'm also scheduled in Canton at this time. Do I need to stay around or may I go?
That's up to you. If she tests positive, then I guess we can call you or something.
Okay, so I'll have my phone.
Mr. Weiner.
John Bearden.
All right, these are cause number CR 20-0628 and 0629-392. Both styled the state of Texas versus John Bearden and both set for discovery status. Is this the same announcement?
It's the same as Ms. Bearden.
All discovery has been provided, pretrial intervention,
That's correct.
negotiation.
No restitution that we have to look at.
That's right. Same announcement as the previous case.
Okay. All right, then, Mr. Bearden, the court deems discovery status is held. Your next court date is May the 5th at 9 a.m. for pretrial. If y'all work it out before then we'll take it off.
Thank you, Judge.
Right, and as soon as you receive your reset notice, Mr. Bearden, you're free to go.
Thanks, John. Then Robert Hocutt, Judge.
Robert Hocutt.
He's just outside.
It's cause number CR 20-0713-392, the state of Texas versus Robert Hocutt, set for discovery status. State.
Judge, all this discovery's been provided.
That's right. This was a case that Ms. Palmer had a conflict on. So we're kind of, I think the court basically set this for discovery status just to give the county attorney's time to kind of go through the
Sure.
file. And so we've
Is there an
received
offer?
everything.
The last offer was 20 years.
20 years.
We are continuing to negotiate potentially on a cap and an open plea to the court.
Okay. All right. Well, then, Mr. Hocutt, the court deems discovery status is held. Your next court date is May the 5th at 9 a.m. for pretrial. And so as soon as you receive your reset notice, you're free to go.
Judge, that's all I have, maybe.
Yes, ma'am. Appreciate you coming over.
Thank you.
And Judge, that's all I have. May I be excused as well?
Sir, everything going all right?
Yeah, yeah.
Let me know if you need anything.
Appreciate it.
Stevens.
Savannah Borky, Your Honor.
I just looked up the paper on it.
I got you. Ms. Boykin. Can I see the indictment? This is cause number CR 20-0644-392, the state of Texas versus Savannah Boykin. This is set today for discovery status. State.
State's ready. All discovery's been provided, Your Honor. We've made 2 offers in this case, one for probation. And the other offer is 3 years.
All right, ma'am, the court, sorry, go ahead, Mr. Stevens, you need anything?
We do have the discovery.
Or a lab or a result outstanding? I just want to make sure everything's in. All right, well then, the court deems discovery status is held. Ms. Boykin, your next court date is May the 5th at 9 a.m. However, based upon the nature of your charge, I'm going to order you to take a drug test today. We'll go take the test. When you get done, come back in the courtroom and we'll go over the results together. Don't leave until we talk. George Smith.
George Smith, Your Honor.
George Smith, come on up, sir. These are cause number CR 19, or this is, sorry, cause number CR 19-0767-392, the state of Texas versus George Smith. And let's handle the pretrial first. Any pretrial from the state?
Yes, Judge, we'll have our standard motion.
No objection.
Granted, and on behalf of Mr. Smith.
No formal pretrial.
All right, then, Mr. Smith, then the court deems pretrial is held. Your next court date is May the 5th at 9 a.m. for status, and that'll be your last day to resolve your case by plea bargain or otherwise, or it ends up on the trial docket. And now there's also been a motion to reduce bond filed.
Actually, a motion to set bond, Your Honor. Just so the court's aware, March the 5th, he failed to show up in court. And so now we're coming before you, Your Honor, to try to get a bond set.
Okay, are you ready?
Yes, sir.
And state, ready?
State's ready.
And are we going to hear testimony from your client for the limited purposes of bail?
Yes, sir.
All right, sir, if you could raise your right hand the best you can.
Yes.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Now you can lower your hand. Mr. Stevens.
Thank you. Please state your name for the record.
George Ray Smith.
George.
You're gonna have, he's gonna have to speak up. I can't hear you.
George Ray Smith.
He has to hear you. and She has to. Okay. Okay. Now, about how long you been in jail right now?
Little about a month.
Okay. Now, you heard me tell the judge that you're being held without a bond because you failed to show up in court March 5th. Is that correct?
Yes, sir.
Okay. You had told me that you actually had moved, you put in a change of address, and apparently the mail didn't get forwarded to you. Is that correct?
Yes, sir.
Okay. Have you ever before March the 5th failed to show up in court or missed any other court dates ever in the past?
No, sir.
Okay. And was it, you didn't intentionally fail to show up in court, right?
No, sir.
You were unaware that it was set.
Yes, sir.
Now, the bond had been set at 8,500. Is that correct?
Yes, sir.
And we're going to ultimately be asking the judge just to set the bond back at 8,500 again, correct?
Yes, sir.
Okay, now, for employment purposes, who do you work for?
His name's Tony White.
Okay, and actually, Mr. White is here today out in the lobby. Is that correct?
Yes, sir.
Yeah, Judge, I'm just going to say his employer's here. I didn't bring him into the courtroom because he's wearing shorts. He's not appropriately dressed. Now,
Going out and go long pants.
All right, hold, sir.
oh, okay.
Have a seat.
Yeah, thank you.
Okay, that's his employer, Judge. Tell me, how long have you worked for Mr. Tony White?
About 7 months.
Okay, and what do y'all do?
What he does is he buys property online, houses and stuff like that. And I go in and I survey them first to see what kind of damage or what kind of work we need to do to the houses. And when we do that, he has a crew come in and I supervise the crew.
Okay. And it's a full-time job, correct?
Yes, sir. It is.
Okay. And where do you live?
Right now at 104 Lake Shadow Circle.
And where?
Gun Barrel.
Gun Barrel.
Lake Shadow Circle. No, Lake Shadow Circle.
Lake Shadow.
And how long have you been at that address?
For about 6 months.
Okay, and who all was there with you?
Just me and girlfriend Jennifer right now.
Okay. You got transportation to get to and from the courthouse?
Yes, sir, I do.
Okay. And if the judge were to, reinstate that $8,500 bond or set another bond, are you going to make sure you make all court
Oh,
appearances?
yes, sir. Yes, sir.
Okay.
I'm not-
And matter of fact, your employer's here. And I spoke to your employer. He's even willing to stay on you, so to speak, to make sure you make your court appearance, do what you're supposed to, correct?
Yes, sir.
Okay. Are you asking the judge to set the bond at 8,500?
Yes, sir.
Okay. Pass the witness. Sean.
Strong.
Mr. Smith, you said that you did not receive a letter for your March 5th. 2020. Is that correct?
No, sir, I did not.
Okay, but were you not here in open court on February 10th? of 2020?
Yeah, that's.
What I show on my docket sheet, and that he received notice in court,
I was going to ask you if you
Oh.
took notice of that hearing and that there
will do so. The court takes judicial notice that he appeared on February 10th in court. He was in the lobby due to an illness. We held discovery status, and he received written notice of 8:30 a.m. Setting on March the 5th of 2020. And on March the 5th of 2020, he didn't show.
nothing further.
Nothing further, Your Honor.
What about this notice?
Well, Your Honor, I
We don't send.
I had
mail
forgotten,
notices.
Judge, I had forgotten about the notice being given to him, okay? Because when we spoke in the back, he had said he didn't get a letter or anything from it. He had moved, and so our address and our file, the letter had gone out to the previous address. But nevertheless, we're still here to judge today, and we're asking to set a bond, a reasonable bond in this.
Well, but I mean, I have a credibility issue now because his, if he's told the court, well, I didn't show up because I didn't get my address changed and my mail didn't forward. Well, he didn't get him. He didn't get a mail in a setting. He was given it in person. And so I guess I'm concerned that he won't show up again. Boss, will you make sure he shows up?
Absolutely.
All right, then the court's going to grant the motion to set bond. The court sets bond at $8,500 surety bond. People, and the only reason I'm doing it because you can't go anywhere now without seeing a help wanted sign because the government's just giving money away and nobody wants to work. And so you need to work and he needs you.
Yes, sir.
But if you don't show up for court again, I can't promise you that I'll set another bond.
Yes, sir.
All right, your bond's set at $8,500 surety bond. And your next court date is, where was I? at? May the 5th, 9 a.m.
Okay.
We'll go.
Yeah,
Notice of
yes.
that.
Thank you. You have a trial on your-
Court order on the last case on this point.
Mr. Stevens,
On page 8, on page 9, set caps.
Mr. Capps. These are cause numbers CR 20-0702 and 0703-392, both filed in the state of Texas versus Seth Capps, and both set for discovery status.
Judge, all discovery has been provided in this case. We have reached an agreement. We're kind of in the middle of that agreement. We're going to end up going to county attorney's office on a listen. And so we're just waiting on a cause number. from the county.
Okay.
And that will resolve both problems.
That's correct, Your Honor. We have received all the discovery. I anticipate that this case will be resolved before the next date, but if the court wants to go ahead and set those dates for tracking purposes, we anticipate it'll be resolved here within the next week or so.
All right, well, Mr. Capps, then court's going to set your case for pretrial for May the 5th at 9 a.m. And if the court's presented with a motion to dismiss before then you won't have to be here. But if not, then I need to see you on May 5th. All right, sir, as soon as you receive your reset notice, you can have a seat.
In my other case, Your Honor, we're working on some plea papers.
Yes, sir. Ms. Moore.
On pages 4 and 5, I believe.
Mr. LeBlue. All right, these are cause numbers CR 20-0387, 0388, 0706, and 0707-392. Both style or all style, the state of Texas versus Levi LeBlue, and all set for discovery status, other than the 0387 and 0388, which are set for status. So where are we at?
All discovery has been provided to the defense. We have made an offer for all cases.
And that is,
The offer is 45 years, and then that's the highest offer.
Gotcha.
And I don't believe I do have all the discovery, Your Honor. There's, what has been provided to me are offense reports involving the evading and unlawful possession of firearm by felony. I don't see a report. I went through everything again this morning that is a theft of $2,500 or more during a disaster declaration. That may be the same report as in the burglary.
that's the first time I've ever seen that enhancement.
So I couldn't find that report. I don't.
We'll double check.
Okay, if y'all can, I mean, that's why we have discovery status, so we can resolve these. So if y'all could
And I don't
check.
have any discs or videos or anything of that effect that was.
We'll make sure that she gets everything.
All right, and well then, let's see. So what I'm gonna do is I'm gonna hold these older, the 387 and the 388 cases up and set the new cases for pretrial on May the 5th. And then the other two cases will be set for May the 5th as well for status at 9 a.m.
Thank you, Judge.
And Mr. LeBlue, based upon your history, this court, I'm gonna order you to take a drug test today.
Yes,
Probably knew that was coming. So you'll go take the test. When you get done, you know the drill. Come back to the
Alright.
courtroom and we'll talk about it.
Your Honor, I have CPS report across the hall. So if y'all
Yeah, I know she's running over there.
need me with the drug test. y'all-
We'll find you.
Thank you.
All right, let's see. It looks like we've handled the business. We'll go ahead and move to Zoom now. Mr. Green is right there in front of me, so I'm going to start with him. Mr. Green, you got me?
Yes, sir.
All right, and who do you got?
I have Holly Goff, who is appearing by Zoom, Your Honor. She needs to unmute herself, or I don't know if that's, there she goes.
Ms. Goff, can you hear me?
Yes, sir.
All right, I'm gonna call your cases then, or your case, sorry. It's cause number CR 20-0447-392. State of Texas versus Holly Goff, and this is set for discovery status. State,
State's ready. State has provided all discovery to the defense. We've made two offers in this case. Both offers involve count one. The first offer is for probation, 2-year state jail, probated for 5 years. The second offer is a 10-month state jail offer, and we will take into consideration a pending Belgian.
Judge, we do have discovery. We do have the plea offers, though. I have not had an opportunity to discuss those with Ms. Goff, but that will be done prior to our next setting for pretrial.
all right, may I see the indictment? Yeah, we're moving around. I'm almost ready to take this blast down.
Put some little holes right here.
All right, Ms. Goff, now she's appearing via Zoom. Is she concerned with the coronavirus? Is she ill?
Judge, I know the court doesn't recall this. Last time she appeared in court, she was a bench warranted from a TDCJ ISF facility. She has since been released from that facility, but she is subject to electronic monitoring and can only travel so far away from her home in Dallas.
Well, I'm sure it'd be a good excuse if she were in district court, but I understand.
Well, and she notified me last week while I was out in North Carolina visiting my daughter that there was an issue with the electronic monitoring and there wasn't any way that I could get that resolved in time for her appearance today.
Understood. All right, well, Ms. Goff, I'm going to require you to be in person on May the 5th at 9 a.m. for pretrial. And I'm just going to tell you right now, based upon the nature of the charge and the allegations in the indictment, I'm going to drug test you.
Okay.
And so I'm going to require you to appear in person on May the 5th at 9 a.m. unless you have symptoms. And then we'll go from there. So it's set for pretrial, May 5th. The court deems discovery status is held.
Thank you, Your Honor.
Yes, sir. We got Mr. Gonzalez next.
Yes, he's in custody, Judge.
Mr. Gonzalez, come on up. Ms. Goff, you can go ahead and log off now. All right, this is cause number CR 20-0616-392, State of Texas versus David Gonzalez Jr. And set for discovery status, Mr. Strong.
Yes, Judge, states provided all discovery. We have currently 2 offers. One offer is 20 months state jail. And we will take care of a new felon, take that into consideration. The other offer is 15 months on this case only. We'll have to do that out. Legal waiting on.
Was it a PCS?
It is, Your Honor.
Okay. Mr. Green?
Judge, we have all discovery. I do have those plea offers, and we'll make sure that I discuss those with Mr. Gonzalez prior to our pretrial hearing.
How long has he been in jail? Mr. Green?
I think he's been in jail since September.
All righty. Mr. Gonzalez, then the court deems discovery status is held. Your next court date is on May the 5th at 9 a.m. for pretrial. So we'll see you back on that date. Thank you, sir.
And that's all my business, Judge. May I be excused?
Yes, sir. Appreciate you.
Thank you.
Let's see. Next we have Mr. Murphy.
Judge Joel Baker appearing for Joe Murphy.
Baker on behalf. I got you. I just
Yes.
read the name, didn't even pay attention to your face.
Yes, sir. We've got Colby Gillum this morning, and we do have discovery, and we
Well,
can.
let me call it real quick.
Yes, sir.
Let's see, Mr. Gilliam, come on up, or Gillum, come on up. These are cause numbers CR 20-0489 and CR 21-0051-392, and both are styled the State of Texas versus Colby Gillum, and both set for discovery status. Mr. Strong.
Discovery's been provided, Your Honor. There are offers in these cases, 12 months state jail, concurrent with each other, and we'll take it.
And Mr. Baker?
That's correct, Your Honor. We do have discovery. We have those offers, and we can schedule these matters for pleas. Or we can do it on May 5th, or we can do it before.
May 5th? Kevin's saying May 5th.
Okay.
Mr.
Yes, sir.
Gillum, you're the one in jail. Is that good for you?
Yes, sir.
All right, well then we'll set your case for a plea on May the 5th at 9 a.m.
Thank you.
Thank you, Your Honor.
Yes, sir.
Have a good
Is
day.
that all you got?
Yes, sir.
We'll see you. And next we have Mr. Steele.
Morning, Judge.
Morning, how are you?
Good, how are you?
Good. You got, let's see, a few cases. First is, let's just start at the top. Marty Matthews.
Yes, Judge. There was, you all sent a link for the discovery. I had some problems downloading it, but I drove down there yesterday. I've got the discovery now.
Let me go ahead and call it then.
Okay.
This is cause number CR 20-0645-392, the State of Texas versus Marty Matthews, set for discovery status. State.
Judge, discovery's been provided in this case. There is an offer currently. It's 12 years.
And Mr. Steele.
Yes, Judge, we have discovery. Had a problem with the download on the link, but we have discovery now. I drove down and picked up the discovery, and I met with Mr. Matthews yesterday. I wasn't sure what the offer was at the time, but now I'm aware of it, and I'll go down there and talk to him again.
You got that, Mr. Matthews? All right, well then the court deems discovery status is held. Mr. Matthews, your next court date is May the 5th at 9 a.m. and that's for pretrial.
I wanted to ask, is there any way I can get a bond reduction?
I can't do things unless they're properly filed and in front of me.
Okay.
And there's a reason for that because the state has to have notice.
All right.
Okay,
Marty, Yeah, Marty, I'll file a motion for bond reduction for you. Okay?
All right, thank you.
Thank you, Mr. Mathis. All right, Mr. McNair. All right, these are cause numbers CR 20-0319 and 0664-392, both styled the state of Texas versus Matthew McNair. And let's see, the discovery status is set on 0664. Mr. Strong?
Yes, Judge, all discovery has been provided to Mr. Still. And there is a current offer right now for 30 units on that call, and we will see you guys soon. Over call CR 20-0319.
And then on the status case, I guess with the offer, I understand. All right, Mr. Steele?
Yes, Judge, I do have discovery, and the state and I are in negotiations, and we're working on it.
Mr. Still and I probably need to talk about some things.
I hear you. All right, well then what I'm going to do, Mr. McNair, on this, the older case, I'm just going to reset the status on that one. The 0664 case, I'm setting for pretrial on May the 5th at 9 a.m. and they'll both be on that date, okay, sir? All right, you can have a seat.
Judge.
And finally, Miss Mooneyham, come on up, ma'am. I'll need to see the document sheet on her. They're line through. All right, these are, or this is cause number CR 20-0505-392, the state of Texas versus Amy Mooneyham, and set for status. Mr. Strong.
Judge, all discovery has been provided. There is a current offer of 5 years prison. However, Mr. Still and I are kind of in this case, so it may still come to the table.
Mr. Steele.
Judge, I was hoping for status, for lack of a better word, status is your day that you got to make a decision or go to trial docket. Is that correct?
Pretty much, but I'm a little more lenient due to this Chinese virus.
Yes, sir. I would ask for one more status and see whether or not we can work this out.
Okay. Ms. Mooneyham, that all right with you?
Yes.
All right, well then I'm going to reset your case for May the 5th at 9 a.m. for status. However, I'm going to order you to take a drug test today. So you'll go with probation, take the test. When you get done, come back in the courtroom, don't leave, and we'll talk about the results.
Yes, sir.
Judge, I'll stay on until we get the results.
Yes, sir. Appreciate you.
Thank you, Judge. My excuse for at least.
Yes, sir.
Yeah, okay.
Oh, yeah. I thought you'd called my case. Apologize.
Oh, you're good. I was getting ready to call you. I was trying to handle all these. We seen Mr. Castleberry? All right, we've got, who do we have here?
Shamar Willis, Your Honor.
All right.
Discovery status.
I don't know you by sight, sir. You're the only male on here that he's representing, so. It's CR 20-0681-392, the state of Texas versus Shamar Willis. And this is set today for discovery status. Mr. Scott.
Your Honor, I was reviewing the discovery for this hearing and I have the written documents, but it appears I don't have any of the DVDs or CDs that are spoken about and photographs, and I just need those. And I should have everything.
Yes, and I reached out to Mr. Scott, I'm waiting for some medical records and restitution, did make an offer of 5 years deferred. We're getting all those discovery to Mr. Scott.
So here's what I'm going to do. If the state's still waiting on them, I'm just going to reset discovery status to May the 5th.
Yes.
The 5th, Your Honor.
May the 5th at 9 a.m. Yes, sir. All right, Mr. Willis, as soon as you receive your reset notice, you're free to go. Remember any conditions of bond you may have. Sheila Crady?
Sheila Crady, yes, Your Honor.
All right. These are cause numbers CR 20-0685 and 0686-392, both styled the state of Texas versus Sheila Crady, and both set for discovery status.
Your Honor, I had filed a motion for a competency and insanity evaluation on Ms. Crady. That was a few months ago, and I'd forwarded the stuff to Dr. Allen, and I checked back up with him several weeks later, and he had not received it. So he said he was going to go meet with Ms. Crady, and she's informed me that she has met with the doctor, but I don't have a report yet.
Do you know when that was?
It's like maybe a month ago.
A month
maybe
ago.
that-
Okay, well, I'll follow up with Dr. Allen. He has not sent me anything yet.
Okay, yeah, if you would, and then I'll just reset discovery status for May 5th.
Thank you, Judge. Last time I checked, the results were pending, so.
Okay,
And if maybe the state and I can do an agreed order if she's deemed to be incompetent by Dr. Allen.
Well, they said I should be going home today because the cops tried to beat me up.
Okay. Well, I'll look into that.
okay, May 5th, 9 a.m.
Thank you.
Y'all-
Thank you, Judge.
y'all look into it. Yep. Thank you, Ms. Crady. You can have a seat.
That's all I have until this afternoon, Your Honor.
All right.
Well, I had an arraignment, but I waived it, so I don't think it's on the docket. Thank you, Judge. I'll see you
Yes,
this afternoon.
Okay, I saw Miss Altier earlier. Mr. Castleberry is missing in action. You're in the butt? Huh? I'm gonna go through here. If you're here, I don't need you to stand up. Just let me know you're here. Bradley Mosley? He's in the back, okay. Sheila Smith? Okay, we're waiting on your attorney. He's in CPS court across the hall. I think that's everybody. Jeffrey Soto? Back with Mr. Stevens. All right, well, then we'll, if we can find out where, if Mr. Castleberry could be so kind as to when he has a break, come in and handle his felony business, that'd be great. All right, let's see. I think we got some stuff ready, Ms. Altier.
Yes, Your Honor. Bradley Mosley is set for status and arraignment. However, we have worked out a plea and are accepting a plea offer that will take care of both cases, all cases. for him.
Mr. Mosley, come on up, sir. So he's pleading on both of them?
Yes, but he has not been arraigned on this.
Okay, let's go ahead and arraign him on these new, on the new case. All right, this is cause number CR 21-0057-392, the state of Texas versus Bradley Mosley, set for arraignment. Ms. Altier.
Yes, his name is spelled correctly on the indictment. He understands the nature of the charges. We waived the formal reading and informed the court that this case will be included in the plea agreement that we've reached today.
I can't hear you.
Okay.
Did he enter a plea of not guilty?
He is, well, he can enter. the
For
plea
purposes
not
of
guilty.
arraignment, does he, I'm going
All
to enter
right.
a plea of not guilty on his
Yes,
behalf. then.
but that will be included. This case will be included.
No, I understand, but this is a totally separate hearing. So
Okay.
for purposes of arraignment, then note your plea of not guilty, Mr. Mosley. All right, and now that case is adjourned. All right, now I'll call CR 20-0705 and CR 21-0057-392, both style of the state of Texas versus Bradley Mosley. And let's see, a plea has been presented to the court on each of these cases. Is the state ready?
State's ready, Your Honor, on both calls.
And on behalf of Mr. Mosley,
Defense is ready, Your Honor.
then sir, is your name Bradley Alexander Mosley?
Yes, sir.
And are you the same person that was originally indicted by a Henderson County grand jury in this state jail forgery of a financial instrument and this state jail felony offense of unauthorized use of a vehicle?
Yes, sir.
And get you to raise your right hand the best you can, please. Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can lower your hand. Mr. Mosley, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not a U.S. citizen and you enter into these plea bargains with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Mosley, have you ever been treated for any mental health or emotional issues? Do you understand what's going on in here today?
Yes, sir.
And Ms. Altier, do you believe your client is competent?
I do, Your Honor.
And the court's going to find he is competent. Mr. Mosley, I know that you've already been arraigned on each of these cases. However, would you like the prosecutor to read the indictments against you out loud here in the courtroom?
No, sir.
All right, but do you understand your charges?
Yes, sir.
Well, as indicted, each of these charges is a state jail felony. A state jail felony carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine not to exceed $10,000. Do you understand the range of punishment in
Yes, sir, I
each
do.
case? And the plea bargain in each of the cases?
Thank you, Judge. In CR 20-0705-392, the state is going forward on paragraph A of the indictment. That agreement is for 18 months state jail. No fine. There is attorney's fees and court costs. There is restitution in the amount of $302.37 payable to Texas Trust Credit Union in Athens, Texas. This is to run concurrent with CR 21-0057-392, and the state of Texas would ask this court to take into consideration two unfiled felonies, a identity theft and a possession of controlled substance, both state jails.
Is that your understanding of the plea bargains, Mr. Mosley?
Yes, sir.
And is that your understanding, Ms. Altier?
It is, Your Honor.
Well, Mr. Mosley, a few minutes ago, you told me you could read and write the English language. I'm going to go over a couple of these documents with you. The first is the agreed plea recommendation sheets. There's one for each case. Did you read and go over those with Ms. Altier?
Yes, sir, I did.
And did you sign both of them?
Yes, sir, I did.
Did you also go over the back with her?
Yes, sir.
And did you sign each of them on the back?
Yes, sir, I did.
Do you have any questions about it?
No, sir, I do not.
The next document I want to show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Now, there was one for each of these pleas, each of the cases, but I'm only showing you one. but I'm going to ask you, did you read and go over this document for each case with Ms. Altier?
Yes, sir, I did.
And did you sign it?
Yes, sir.
Do you have any questions about it?
No, sir, I do not.
Do you have any questions about any of the documents that you read and went over with her?
No, sir, I do not.
Well, if you read and went over these documents with her, I know that she explained to you that you have many constitutional rights in each of these cases, including the right to trial by jury. Do you want a jury trial in any of these cases?
No, sir.
Do you want to enter into these plea bargains?
Yes, sir.
Then I'll ask you, sir, in cause number CR 20-0705-392, as to paragraph A of that indictment, are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
And now in cause number CR 21-0057-392, to that state jail felony offense as alleged in the indictment, are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I hear the evidence in each
Thank you,
case.
Judge. The state offers states exhibit number 1 and states exhibit number 2 and CR 20-0705-392. The offense report and the discovery compliance, and we'll enter also states 1 and states 2 in the next cause number CR 21-0057-392, which is also an offense report and discovery compliance for that cause.
We have reviewed with no objection, Your Honor.
Right, and those are all admitted. Anything else from the state?
Nothing further left in court.
We ask the court to accept the plea offers on both cases, and we rest in close, Your Honor.
All right, then, Mr. Mosley, in cause number CR 20-0705-392, based upon your guilty plea to paragraph A, as well as the evidence, the court has enough evidence to find you guilty and does find you guilty of that forgery of a financial instrument in paragraph A. The court will accept the plea bargain, and sentencing you considers the 2 unindicted cases that are annotated on the agreed plea recommendation. The court sentences you to 18 months in a state jail felony facility with credit for 161 days and orders you to pay your attorney's fees, court costs, and restitution to Texas Trust Credit Union. In this case, will run concurrent with CR 21-0057-392. And in that case, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that state jail felony offense. The court will follow the plea bargain, sentences you to 18 months, state jail with 161 days credit, and orders you to pay your court costs. And of course, this case will run concurrent with the previous case. A few other things we need to go over, Mr. Mosley. In each of these cases, did you have an opportunity to review the judgment of conviction?
Yes, sir.
In each of those, was your name, the charge, and the time credit correct?
Yes, sir.
All right, and finally, sir, now that you've been convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. Those are actually legal terms. So if you have any questions about it, refer to the document in your plea packet or consult with an attorney.
Yes, sir.
You're now remanded back to the custody of the sheriff for transport to the appropriate authorities to serve out your sentence. Good luck, Mr. Mosley. You can see Mr. Halbert right here to your right.
I have nothing further this morning. May I be excused?
Yes, ma'am. Thank you.
Thank you.
Let's see. Kelly Snodgrass, you're free to go, sir. You passed your test. We'll see you in May. Savannah Boykin. We have a Savannah Boykin. Savannah Boykin. Ma'am, you passed your test. You're free to go. We'll see you in May. All right, and then I need to see Martha Beat up here and Amy Mooneyham. Mr. Steele, you with us? I got Miss Mooneyham's results back.
Yes, Judge. Can you hear me?
Yes, sir, I got you. And on her docket sheet, Miss Mooneyham, have I tested her before?
previous test, but I think this is the first test on this new.
Do we have the docket sheet on the previous case? I'm trying to figure out if she's ever tested positive in my court, because it's the same bond, just a different case. Or, I mean, it's a re-indictment. Is there a way we can find that out? Hold on a second. Miss Biat, who is your attorney?
Honestly, yes, I
And Thompson?
really not even really talked to me about nothing.
Well, Miss Biat, it'd be her first test, would it not? Okay, all right. Cause number CR 20-0666-392, the state of Texas versus Martha Biat. Miss Biat, based upon the nature of your charges, the court had ordered you to take a drug test earlier this morning. You've taken that test and it appears as though you're positive for methamphetamine. And it appears also that you allegedly admitted to smoking it on April the 3rd, just a few days ago. However, this is your first test. And so everybody gets their one free chance with me. So Ms. Biat, if you don't already have conditions of bond, I'm placing you on conditions of bond. Sure she does, it's CR 20, is that correct? Your conditions of bond are no alcohol, no drugs that are not prescribed, no illegal drugs, and no marijuana. I don't care what state you're in, it's still illegal here in
I've
Texas.
already checked in and getting classes and trying to get into the rehab to keep myself clean. And I've already moved away from the people that.
Good, sounds like the first step you there is, but I don't want you to say anymore because your attorney's not here and the state's here, and anything you say they can use against you. And so I'm going to get you conditions of your bond. I will see you in May. Odds are I'm going to drug test you again.
Yes, sir.
If you test positive in May, I can't promise you go out that exit door. You may go out this door.
Yes,
You
sir, I
understand that? All right, so as soon as you receive that, those conditions of bond, and if you need help, it sounds like you've asked, just ask. Lots of help out there. I think it was May 5th. 1:30 or 9. May 5th at 9 a.m. All right, Ms. Mooneyham, come on up. And Mr. Steele's here as well, appearing via Zoom. This is cause number CR 20-0139-173, State of Texas versus Amy Lynn. Actually, that was the old case cause number. CR 20-0505-392. State of Texas versus Amy Mooneyham. Ms. Mooneyham was ordered to take a drug test based upon her indicted case. Appears as though she's tested positive for methamphetamine, has denied use. And Mr. Steele, I will tell you in the prior cause number, this was a re-indictment. She had tested positive on June 11th of 2020. So I'll let you say what you want to say to the court, Mr. Steele.
Yeah, Judge, I haven't seen the test result, but my understanding from talking to my client is the test came back positive for methamphetamine, but possibly negative for amphetamine, which the person who was testing thought that was unusual. My client,
Well,
yep.
I've seen it. If it's been a while, or do you know?
She's only positive for med. She said she has a prescription for some medication.
Okay. All right, go ahead, Mr. Steele.
Yeah, and that's right. She provided me some information that she takes something called metformin, METFORMIN for diabetes, and she provided me something that says that medication can occasionally result in a false positive for methamphetamine, Judge. I guess I would only ask that if the test could be sent off for either further screening or that you give her another chance. She has tested clean
Right.
since the June test.
Yeah,
So-
she tested clean in August of 2020. Here's what I'm gonna do. I'm gonna send it off. Ms. Mooneyham, I'm just gonna leave you where you're at right now, but you know, you do have conditions of bond on you. And I placed those on you already. And so just remember those conditions of bond. We'll send it off for confirmation. I'll see you in May.
Thank you.
Yes, ma'am.
Thank you, Judge.
Yes,
That be
sir.
excused?
Yes, sir. Appreciate you waiting around.
Yeah, have a good day. I appreciate it. Thank you.
Here is the case we just did. But it's been a while. Yeah. Was my understanding. I'm positive. I'm positive. I'm good. Oh, we got Mr. Castleberry. Mr. Castleberry.
I have Sheila Smith on page 1 for a plea.
Thank you for printing that. That was on the spot. Well, these are different. Cheaper. You see the face shields he got that were made in China? Well, give me just a minute. Let me get paperwork here. All right, this is cause number CR 20-0340-392. State of Texas versus Sheila Michelle Smith. This was set for discovery status today. However, a plea has been presented to the court. Is the state ready?
State's ready, Your Honor.
And on behalf of Ms. Smith,
Defense is ready, Judge.
ma'am, is your name Sheila Michelle Smith?
Yes, sir.
And are you the same person that was originally indicted by a Henderson County grand jury for state jail felony offense as enhanced to a third-degree felony for forgery of a financial instrument?
Yes, sir.
I get you to raise your right hand the best you can. Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
You can lower your hand. Ms. Smith, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not a U.S. citizen, and you enter into this plea bargain with the state, you can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Ms. Smith, have you ever been treated for any mental health or emotional issues?
No, sir.
You understand what's going on in here today?
Yes, sir.
And Mr. Castleberry, do you believe your client is competent?
I do, Your Honor.
And the court's going to find she is competent. Ms. Smith, I know that you were already arraigned on this case. However, would you like the prosecutor to read the indictment against you out loud here in the courtroom?
No, sir.
But do you understand the charge?
Yes, sir.
Well, as indicted with these two enhancements, that charge is a third-degree felony. A third-degree felony carries a punishment range of not less than 2 years, no more than 10 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
However, it's my understanding that you have this agreement with the state whereby you would plead guilty to the underlying charge as well as to one enhancement paragraph.
It's gonna be 2, Your Honor. I think it says 1, it should be both.
That's correct, Judge.
So she is pleading to the third?
It's a 2 to 10 with both enhancements.
It's okay. I see it. I see the 2 years. I got it. All right. So it's my understanding that you're going to plead guilty to the underlying charge as well as the two enhancement paragraphs, which would make this a third-degree felony.
Yes, sir.
Did I go over the range of punishment for a third degree? The range of punishment for a third-degree felony is not less than 2 years, nor more than 10 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. You understand that range of punishment? And the plea bargain?
Thank you, Judge. It's 2 years TDC on a state jail offense and it's a punishment range with a fine of true up plus court costs.
And attorney's fees, I got it. All right. And I'll get to that in a moment. Just to be safe, Ms. Smith, if for some reason you were to go to trial and they found you guilty, but the enhancement paragraph's not true, it'd be a state jail felony. And a state jail felony carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes.
The law says I have to go over the range of punishment.
Okay.
All right. And the plea bargain in the case, you already told me that.
Yes.
Is that your understanding of the plea bargain, Ms. Smith?
Yes, sir.
And is that your understanding, Ms. Castleberry?
It is, Your Honor.
The only question I have is the bill that you submitted was for $950 and the attorney's fees on here are only for $500.
It might say zero, so we'll have to just report. That's why I thought maybe we were continuing. Oh, so just need to figure out.
But I guess,
Our attorney, but I didn't object to it.
it's a state jail plea, which really, this is not a state jail plea. This is a plea in a non-3G. Further higher. What are the additional cases on here? These 3 additional cases.
Judge, I don't believe that's my voucher.
Just somebody, oh, that's somebody else. I'm sorry. This was in this packet, or maybe it got hooked up in the bottom of it. I just go over the paperwork I thought it was in here. I'm sorry. So the attorney's fees are 500.
Okay.
All right, so that's everybody's and my understanding of the plea bargain.
Okay, yes, yes.
It's a really, is this a Monday for us? It feels like it. All right, well, Ms. Smith, a few minutes ago, I asked if you could read and write the English language. You told me you could. I'm going to go over a couple of these documents with you now that I'm straight. First is the agreed plea recommendation. Did you read and go over this with Mr. Castleberry,
Yes, sir.
including those attorney's fees?
Yes, sir.
And did you sign it?
Yes, sir.
Do you have any questions about it? Did you also go over the back with it?
Yes, sir.
And did you sign it?
Yes, sir.
Any questions about it? All right. The next document I want to show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both of those pages?
Yes, sir.
And did you sign it?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents you went over with Mr. Castleberry?
No, sir.
Well, if you read and went over these with Mr. Castleberry, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial in this case?
No, sir.
Do you want to enter into this plea bargain?
Yes, sir.
Then I'll ask you, ma'am, how do you plead to that felony offense of forgery of a financial instrument as alleged in the indictment? Guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
And also, as to the enhancement, is it true or not true that in Dallas County, in 2000, you were convicted of the state jail felony offense of credit card abuse?
Yes, sir. True.
And are you pleading true because you are true and for no, because it is true and for no other reason?
Yes, sir.
And then finally, is it true or not true that in Kaufman County in 2000, you were convicted of the state jail felony offense of burglary of a building?
True.
And are you pleading true to that enhancement because it is true and for no other reason?
Yes, sir.
I'll hear the evidence.
Thank you, Judge. State offers in the evidence states 1, the offense report, and states 2, discovery.
No objection, Your Honor.
Admitted.
Nothing further, rest in court.
All right, then, Ms. Smith, based upon your guilty plea and the evidence, as well as on your plea of true in the evidence, the court has enough evidence to find you guilty and does find you guilty of that forgery of a financial instrument. The court also, that's true, follows the plea bargain, sentences you to 2 years in Texas Department of Criminal Justice with credit for 115 days and orders you to pay your attorney's fees and court costs. And a couple more things, Ms. Smith. Did you have an opportunity to review the judgment of conviction in your case?
Yes, sir.
Was your name, the charge, and time credit correct?
Yes, sir.
And finally, now that you've been convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. Those are legal terms, so if you have any questions about that, refer to the document in your plea packet or consult with an attorney. You're now remanded back to the custody of the sheriff for transport to the appropriate authorities to serve out your sentence. Good luck to you.
Thank you.
You can see Mr. Howell.
Okay, thank you.
Hey, at least you can tell that I do look at these and try to compare them. I just got hooked up at the bottom of this one. I was like, it's not making sense to me.
Yeah, that's all. for me.
Yes, sir, appreciate you. And then I threw it at you. I didn't mean to. I guess. Yes, sir. Leon, too. Let me get my paperwork straight real quick. I don't have it in a certain order. I get all messed up. All right, these are cause numbers CR 20-0667-392 and CR 20-0581-392. Both styled the state of Texas versus Jeffrey Soto and both set for discovery status. However, a plea in each of these cases has been presented to the court. Is the state ready?
State's ready, both causes.
And on behalf of Mr. Soto,
We're ready.
sir, is your name Jeffrey Daniel Soto?
Yes, sir.
And are you the same person that was originally indicted by a Henderson County grand jury for this state jail felony offense of possession of a controlled substance and this second degree felony offense of burglary of a habitation?
Yes, sir.
I can get you to raise your right hand the best you can. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. Soto, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not a U.S. citizen, and you enter into these plea bargains with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
Mr. Soto, have you ever been treated for any mental health or emotional issues?
No.
You understand what's going on in here?
Yes, sir.
And Mr. Stevens, do you believe your client is competent?
I do.
The court's going to find he is competent. Mr. Soto, I know that we've already arraigned you on these cases. However, would you like the prosecutor to read the indictments against you out loud here in the courtroom?
No, sir.
But do you understand the charges?
Yes, sir.
Well, as indicted, that possession of a controlled substance case is a state jail felony. A state jail felony carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine not to exceed $10,000. Do you understand that range? Judge?
Yes, sir.
In this burglary of a habitation case, that's a second degree felony. A second degree felony carries a punishment range of not less than 2 years or more than 20 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. You understand that range of punishment? Plea bargain?
Thank you, Judge. In CR 20-0667-392, second degree burglary of habitation case, the agreement was a 10-year deferred probation plus a $1,000 fine, $900 in attorney's fees, $305 court costs. Part of this probation was to do the following conditions: $50 to Crime Stoppers, urinalysis testing, obtain GED within 24 months, 900 community service hours at 10 hours a month, drug offender program, and complete some evaluation. And that is to run concurrent with CR 20-0581-392, the state jail felony, as a 3-year deferred probation plus court costs plus $180 in restitution to DPS. And the conditions are the same except for AA and or NA, and the hours are less at 300. And that's direct.
Is that your understanding of the plea bargains, Mr. Soto?
Yes, sir.
Is that your understanding, Mr. Stevens?
Yes, sir.
And Mr. Soto, a few minutes ago, I asked if you could read and write the English language. You told me you could. Is that correct?
Yes, sir.
I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Now, there's one for each case. Did you read and go over each of those with Mr. Stevens?
Yes, sir.
And did you sign the bottom?
I did.
On the back, certain admonishments and waivers. Did you go over the back of each of these with Mr. Stevens?
Yes, sir.
And did you sign them?
I did.
Do you have any questions about it?
No, sir.
The next document I'm going to show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Now, there's one for each case. I'm just showing you one. Did you sign or did you read and go over those with Mr. Stevens?
Yes, sir.
And did you sign each of them on the back page?
I did.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents you signed and went over with Mr. Stevens?
No, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury in each case. Do you want a jury trial in any of these cases?
No, sir.
You want to waive your right to a jury trial and enter into these plea bargains with the state?
Yes, sir.
Then I'll ask you, sir, in cause number CR 20-0581-392 to that state jail felony offense of possession of a controlled substance, are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes.
And in cause number CR 20-0667-392 to that second degree felony offense of burglary of a habitation, are you guilty or not guilty?
Guilty.
And are you pleading guilty in that case because you are guilty and for
Yes,
no
sir.
other reason? I'll hear the evidence in
Thank
each
you,
case.
Judge. In CR 20-0667-392, state offers states 1 and 2, the offense report and the discovery compliance.
No objection.
Admitted.
And in CR 25-81-392, the state offers 1, 2, and 3 exhibits. 1, the offense report, 2, discovery compliance, and 3, the lab report.
No objection.
Nothing further. Rest and close in both causes.
Rest and close as well.
All right, then, Mr. Soto, in this CR 20-0581-392, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court is going to follow the plea bargain, defers making any finding of guilt, places you on 3 years community supervision. You do have credit for 201 days. That's any sentence you may eventually have to serve, and orders you to pay your court costs, lab fee, and abide by all the regular and special terms and conditions of community supervision. In this case, will run concurrent with CR 20-0667-392. And in that case, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court will follow the plea bargain, defers making any finding of guilt, places you on 10 years community supervision with credit for 201 days, and orders you to pay your fine, attorney's fees, court costs, and to abide by all the regular and special terms and conditions of community supervision. And of course, this case will run concurrent with the prior case. Mr. Soto, have you ever been on probation before?
Yes, sir. A long time ago.
Did you successfully complete it?
No.
So you know what it takes at least to fail it, right?
Yes, sir.
There's lots of things you have to do and a few things you can't do while on probation. Do you know what can happen if you violate any terms or conditions of these probations?
Yes, sir. I could be sentenced up to 20 years.
That's right. That's kind of the good side of a deferred is if you successfully complete it, you can take some steps to get it off your record. If you don't, you're open to the full range of punishment. So here's what can happen. If you violate even one term or condition of this community supervision, a motion could be filed, a warrant would be issued for your arrest, you'd be brought back before the court, and at a hearing, if the court were to find that you violated even one term or condition of community supervision, the court could find you guilty, revoke your probation, sentence you up to 2 years in state jail for this PCS, and up to 20 years in prison for this burglary of a hat. You understand that?
Yes,
All right,
sir.
sir. Good luck to you. I hope I don't see you back in here. I'll sign an order of release. As soon as you get out, you need to report to probation if it's during business hours immediately. If not, you need to report at 8 a.m. the next business day.
Yes, sir.
Is that right? I got it.
Judge may be excused.
Yes, sir. Appreciate you. We'll keep in touch on this other deal.
Yes, sir.
Yes, sir. Thank you. Trying to what?
I was going too fast. I realized it. I was trying to get us moving.
Hey, we did some things. We still got a couple things to deal with though. Levi LeBlue. See you out in the lobby. No. Good for him. Good on you. Surprise me. Surprise me. Maybe.
We need to change this card.
Mr. DeBlue, you have tested negative. I'll see you in May.
Are you serious? Oh.
Well, if you have a question about it, we can have a hearing on it.
Is it possible? Well, oh.
All right,
He's
so
a
maybe what they-
character, Your Honor. He's all jokes.
I know he's all jokes.
This is not Dr. Joking, Levi.
Yeah, that's a negative. I was like, I was expecting something good, but no.
I'm not positive it's negative, but it is negative. Good job.
What they, thank you.
Good job.
Uh,
Your choice of attire in a courtroom though, especially when you have a lady for an attorney, you might
I
want to.
promise you, I will not do that again.
It's okay.
I was barely made it on time and I grabbed this out, I could just match my clothes.
We'll see you back in May, Mr. LeBlue.
I did.
He's got one.
Thank you, Judge. May I state the excuses what's happening?
Oh, you got one more. Jesse Webb didn't have quite the luck. Jesse Webb. I know. He's like, are you kidding me? I was gonna get. Oh, it seems like the worse they are, the more I love them sometimes. My clients are always like, the worse they were, the more I like them. Mr. Webb, come on up. I'm not gonna ask any questions, and so I'm just gonna put you in receive mode only because your attorney's not here. It's cause number CR 21-0110-392, the state of Texas versus Jesse Webb. It's not. Uh-oh. CR 20-0709-392, the state of Texas versus Jesse Webb. Mr. Webb was sent for a drug test earlier this morning based upon his alleged offense. Mr. Webb has tested positive for methamphetamine, amphetamine, and THC, and admitted to swallowing and smoking weed and meth on April the 7th, which is today.
No,
That's the day you thought you admitted it.
that's the day that I did it or admitted.
Well, it says on or about this. I see what you're saying. You got it confused. Because if it was today,
No,
you
sir.
may be under the influence now.
No, sir.
All right. And so, Mr. Webb, everybody gets their one free time with me. I'm now putting you on conditions of bond if you already have them. Does he already have them? CR 20?
He doesn't have one.
All right. No alcohol. These are your conditions of bond. No alcohol. No drugs that are not prescribed. No illegal drugs and no marijuana. I don't care what state you're in or state of mind. No marijuana.
Yes.
And as you can probably guess,
Yes.
the next time you come in May, I'm going to drug test you. And if you test positive, I can't promise you'll go out that door. You may go out that one.
Yes,
And that one leads straight to the jail in a roundabout fashion. You understand?
yes, sir.
All right. As soon as you receive those conditions of bond, you're free to go. See you in May. If you need help, ask. Lots of help out there.
Oh, yes.
A gentleman was just in here. Looks like he got help.
I wasn't on him a whole lot.
You know Levi?
Yeah.
Well, you might have been just as surprised as I was that he was naked.
Yes, sir.
All right. You can go ahead and stand over there, sir, until you get your conditions.
And Judge, I was wrong. That is.
Oh,
I know,
Lordy.
the
That's
PCS is
in
CR 21.
Well, you are spring loaded in the correct position today.